9. When brothers have not yet divided the inheritance they receive from their father, but instead all use the estate together, they are considered partners with regard to all matters. Similarly, all other heirs are considered partners with regard to the estate of the person they inherited. Whenever any of them does business with the resources of the estate, the profits are split equally too. When there were heirs above majority and the others below majority, those above majority improve the estate and increment the split equally. If they said, "See the estate that our father left us, we will work and benefit from the increase." Persons who brought about the increase are entitled to it. This implies provided the increase comes about because of the expenses undertaken by those persons. The value of the estate increased on its own accord. That increase is shared equally. 3. Laws apply if the wife of the deceased was also his relative and had a right to inherit the estate together with her sisters or her cousins. If she increased the value of the estate, the increase is shared equally. If she said, "See the estate that my husband left me, I will work and benefit from the increase," should she increase the value of the estate through investments she made, the increase belongs to her. For the following was applied when a person inherits his father's estate. Improves its value by planting trees and building structures, and afterwards he discovers that he has brothers in another country. If there are minors, the increase in value is divided equally. If they are above majority, since he did not know that he had brothers, he is given a portion as if he was a sharecropper. Similarly, if a brother took possession of the property belonging to a minor and improved it, he is not given a portion as if he were a sharecropper. Instead, the increase of the entire estate is divided equally because he did not have permission to make use of the property. If the following rule applies, one of the brothers took money from the inheritance and engaged in commerce with it. If he is a great Torah scholar who ordinarily does not abandon his Torah study for one moment, profits are given to him, for he would not abandon his Torah study to engage in commerce for the sake of his brothers. 6. The following laws apply when a king appoints one of his brothers who share in the father's estate as a tax collector and accountant to supervise the influx and efflux of the king's monies, or to another one of the positions in the king's service. If the son was appointed in the father's sake, i.e. his father was renowned for his skill, and the king said, "Let us appoint the son instead in order to act graciously to the orphans," the portion that the son receives the appointment receives and any wages he earns in this task should be shared among the brothers. This ruling applies even if that someone is very wise and fit to be appointed on his own merit. If the king appoints him on his own merit, his wages are his alone. 7. The following laws apply when one of the brothers was carrying out transactions on behalf of the household and purchased his servants as his own individual property, or lent money to others and had the promissory notes written to him alone. If he says, "The money that I lent or with which I purchased the servants is my own, it came to me as inheritance from my maternal grandfather, I found the ownerless object or a present was given to me," he is required to verify the authenticity of his statements. Similar laws apply when a married woman was carrying out transactions on behalf of the household and deeds of purchase of the servants and promissory notes were composed in her name. If she says, "The money belongs to me, I received it as an inheritance from my father's family," she is required to verify the authenticity of her statements. Similar laws apply when a widow was carrying out transactions with funds belonging to orphans, and deeds of purchase and promissory notes were circulated in her personal name. She claimed them as her own, saying, "It me as an inheritance, I found the subject or present was given to me," required to verify the authenticity of her statements. If she said, "I took them from the resources of my dowry," her word is accepted. If, however, she does not have a dowry, or in the situation described in the previous clause, she did not bring proof of her statement, everything is assumed to be owned by the heirs. 8. When does the above apply? When the brothers of the widow did not eat separately, whenever they eat separately, we suspect that they saved from their food allowance. Hence, the other brothers must prove that the money was taken from the estate. Similarly, if the brother was managing the funds died, the other brothers were required to bring proof that the money was taken from the estate, even though they did not eat separately. 9. The following laws apply. When one of the brothers is in possession of the promissory note owed to the father, he is obligated to bring proof that his father gave him the note, signing and transferring a document attesting to the fact the note was given as a gift, or that at the time of his death, the father commanded that it be given to that brother. If the brother in possession does not bring proof of this nature, the note must be shared equally as part of the estate. 10. With when does the above apply? With regard to brothers, because the prevailing assumption is that they take from each other. One, however, a promissory note is in possession of another person who claims that the creditor gave it to him, or that he purchased it from him, he may collect the debt. He is not required to bring proof. Claim 11. If one of the brothers took 200 zuz from his share of the estate to study Torah or study a profession, the other brothers may tell him, "If you do not live together with us, we will not give you a food allocation beyond what it would cost for you living with us." For food expenses incurred by an individual living alone are much higher be were to live with others. 12. When a person died, leaving sons past majority and under majority, the other sons cannot be required to receive only what is allocated for the younger son's living expenses, nor may the younger sons be required to receive only what is allocated for the older son's expenses. Instead, the estate should be divided equally. If the older brothers married after the father's death using the funds of the estate, the younger brothers may marry using the funds of the estate and then divided. If the older brothers married during the father's lifetime, may not either request the younger brothers to say, "Let's marry using the funds of the estate as you married." Instead, whatever the father gave the older brothers is considered as a present. 13. The following laws apply when a father married off one of his sons and made a feast for him, paying the expenses himself. It was a wedding gift. If a wedding gift was sent to the son during the father's lifetime, should the wedding gift have to be repaid after the father's death? It should be repaid by the estate as a whole. If, however, the brother paid for the expenses of the wedding feast from his own resources, the brother received the gift and they must repay it from his portion alone. 14. When the father sent a wedding gift to a friend in the name of one of his sons, when that wedding gift is repaid to that son, it is his alone. If, however, the father sent the wedding gift in the name of his son without making any specifications, when it is repaid, it should be repaid to the estate as a whole. To the person to whom the wedding gift was sent is not required to return it unless all the brothers rejoice together with him, for they are all members of the wedding party, and the gift was sent in all of their names. Therefore, if he rejoiced with only several of them, he need only return the portion appropriate for those with whom he rejoiced. The money he repays is shared by the estate as a whole. 15. When the oldest of the brothers dresses and garbs himself in fine raiment, he may purchase these garments from the funds of the estate if this brings his brothers benefit, i.e., because of his fine clothing, his words are heeded by other people. Chapter 10. 1. When two brothers divided an estate and then a third brother comes from overseas, when three brothers divided an estate and then a creditor came and expropriated a portion from one of them, the division is nullified. They should return and divide the remainder equally. This applies even if originally one brother took land and the other cash. 2. When before his death a person commanded that the tone shall be given a palm tree or a field from his property, but the brothers divided the estate without giving that person anything, their division is negated. What should they do? The entity concerning which the deceased commanded should be given to that person, and then they should divide the estate into. It should be given to that person. Then divide the estate into 3. When brothers divide an estate, we evaluate the clothes they are wearing. We do not evaluate the clothes that their sons and daughters are wearing, that they purchased with the funds of the estate. Similarly, the clothes that their wives are wearing are considered as if they have already been acquired by them. When does the apply? The garment, the week, the garment, the Shabbos and festival garments. We evaluate what the women and children are wearing. For the following law applies when a person died, leaving some orphans who are past majority and others who are below majority. If they desire to divide their father's estate so that the older brothers could receive their portion, the court appoints a guardian for the minors and chooses a good portion for them. Once they come of age, they may not protest the division because it was made by the court. If, however, a court erred in its evaluation of the estate's worth and reduced their portion by 6, they may issue a protest. In that instance, any division is made after they come of age. 5. When a person dies, leaving some orphans who are past majority and others who are below majority, he must appoint a guardian before his death who will care for the portion of the minors until they become of age. If the father does not appoint such a guardian, the court is obligated to appoint a guardian for them until they come of age. But the court acts as the parents of the orphan. 6. The dying person ordered, give the minor's portion of my estate to him. Let him do whatever he wants with it. He has the license to deal with his own estate in this manner. Similarly, if the dying person apportioned appointed a minor, a woman, or a servant as the guardian for the minors, he has a license to deal with his own estate in this manner. A court, by contrast, should not appoint a woman or a servant or a minor or unlearned person who is suspect divide terrorist prohibitions as a guardian. Instead, they should seek out a faithful and courageous person who knows how to advance the claims of the orphans and bring arguments on their behalf when it was capable with regard to worldly matters to protect their property and secure a profit for them. Such a person is appointed a guardian of the minors, whether or not he is related to them. If he is a relative, however, he should not take control of the landed property. 7. When the court appointed a guardian and afterwards heard that he was eating, drinking, and making other expenses beyond what could be expected to, they should suspect that he's using the resources of the orphan. They should remove him from his position and appoint someone else. If, however, the guardian was appointed by the orphan's father, he should not be removed in such a situation. It is possible that he found an ownerless article. If witnesses came and testified that he's ruining the orphans, instead he's removed from his position. The guardian agreed that he should be required to take an oath in such a situation, for he's causing the orphans a loss. Similarly, when the guardian was appointed by the orphan's father, who had a praiseworthy reputation, was known to be upright and to pursue the mitzvahs, and he became a glutton and a drunkard who began following paths that aroused suspicion, or became reckless with regard to vows in the shade of theft, the court is required to remove him from his position and require him to take an oath. Afterwards, they appoint an appropriate guardian. These matters are dependent on the perception of the local judge, for each and every court must act as the parents of the orphans. 8. When a minor attains majority, even if he eats and drinks excessively, ruins his estate and follows an undesirable path, the court does not withhold his property from him, nor does he appoint a guardian unless his father or the orphan whose property he inherited ordered the property be given to him, unless he conducts himself uprightly and successfully, or that it not be given to him later. A person who is mentally or emotionally unstable or deaf mute are considered as minors, and a guardian should be appointed for them. Chapter 11. 1. Money belonging to orphans that was left to them by their father does not require a guardian. What instead is done with it? We search for a person who owns property that can be expropriated by a creditor and that is of high quality. This person should be trustworthy, one who heeds the laws of the Torah and was never placed under a ban of ostracism. He is given the money in the presence of the court to invest in a matter that will most likely lead to a profit and will not likely lead to a loss. Thus, orphans would have benefit from the investment of the money. Similarly, if such a person does not have landed property, she gives bars of gold that does not have any identifying marks as security. The court takes the security and gives him the money to invest in a manner that will most likely lead to profit and will not likely lead to loss. Why does he not give golden utensils or golden jewelry as security? For perhaps these articles belong to another person. We fear that in the event of the investor's death, that other person will claim these articles by identifying them with signs. They will then be given to him if the judge knows that the investor was unlikely to possess such articles. How much should be given to the orphans as profit? If the judge estimates, a third of the profits, half of them, or even a fourth of them, if the judge estimates that this is in the best interest of the orphans, such an arrangement is followed. If the court cannot find the person to give money to invest in a manner that will not likely lead to loss, will most likely lead to a profit, they should use a small amount of the money to provide the orphans with their livelihood until they use the money to purchase land or they entrust to a guardian whom they appoint. 2. Movable property inherited by orphans should be evaluated and sold in the presence of a court. If the marketplace is close to the city of residence, we have the articles brought to the marketplace. They are sold, and the proceeds added to the financial resources of the orphans. 3. The following principle applies when a person possesses beer belonging to the orphans, and he's beset by a quandary. If he leaves it in its place until it is sold, it might sour. If he brings it to the marketplace, it might become lost because the factor is beyond his control. Our sages ruled that he should do as he would do with his own beer. Similar laws apply in all analogous situations. Wow, what a problem. I could think of some solutions to the beer issue. 4. When the court appoints a guardian, he is given all the property of the minor, the landed property and the movable property that was not sold. He sells and purchases whatever he determines is necessary. He builds and he destroys, he rents, he plants, sows, and does whatever he thinks is in the best interest of the orphans. He should provide them with food and drink and provide them with their expenses according to their financial capacity and their social standing. He should not be overly generous with them, nor should he be overly parsimonious. 5. When the orphans come of age, the property should be given. The guardian should give them the property of the person whose estate they inherited. He does not have to give them an account of what he purchased and what he sold. Instead, he tells them this is what remains, takes an oath holding a sacred article that he did not steal anything from them. When does he apply? When the guardian was appointed by the court, and whenever the guardian was appointed by the orphan's father or other relatives, he is not required to take an oath because of an indefinite claim. The guardian may dress and guard himself in a distinguishing manner using the funds belonging to the orphans, so that he will be esteemed and his words will be heeded, provided the orphans will benefit from the fact that he is esteemed and his words are heeded. 6. A guardian may sell animal servants, maidservants, fields, and vineyards belonging to the estate to provide sustenance for the orphans. He may not sell these assets and hoard their money. Normally, he sell funds. Normally, he sell fields to purchase servants, nor still servants to purchase fields. Perhaps he will not be successful. He may, however, sell fields to purchase oxen to work other fields. For oxen are the fundamental element of the fields one possesses. 7. The guardian is not permitted to sell a field located far from the city and purchase a field close to the city. Nor may he sell a poor field and purchase a good field, for perhaps his purchases will not be successful. Similarly, a guardian may not enter into a lawsuit to argue on behalf of the orphans with regard to a claim registered against them with the intent of benefiting them. The rationale that they may not be successful in the claim against them will be substantiated. 8. The guardians are not permitted to grant candidate servants their freedom. They may not even take money from the servants that he will be released. Instead, they sell the servants to others and take the money from them with the intent that they grant their freedom. It is those purchasers who release the servants. 9. The guardians should separate tumah and the tithes from the crops of the orphans so that they can provide them with food. We may not feed the orphans forbidden substances. They may not, however, tithe or separate tumah so that the produce will be ready for use. Instead, they should sell it as tevel. Those who desire to make it ready for use will do so. 10. The guardians must make a lulav, a sukkah, tzitzis, shefer, a terrace scroll, tefillin, mezuzahs, and a megillah on behalf of the orphans. The general principle is all mitzvahs that have a fixed measure, whether of scriptural or rabbinic origin, should be made available for them. Although they are obligated to these mitzvahs only as part of their education, we do not, however, levy charitable assessments against their property, even for the sake of the redemption of captives. The rationale is that such mitzvahs have no limit to them. So the Rambam is telling us that that tefillin and mezuzahs and a lulav and esrog, these things have a set limit. Interesting. 11. When a person loses his intellectual faculties and becomes a deaf mute, the court levies a charitable assessment against his properties as if he has the means. 12. Although a guardian does not have to make an accounting, as mentioned above, he must keep a personal account, being extremely precise so as not to incur the wrath of the father of those orphans who rides upon the heavens. As Psalms states, make a path for he who rides upon the heavens, the father of orphans. Blessed be he who grants assistance. Bichman decided this concludes the 13th book with the help of the Almighty. The amount of chapters in this book are 75. Hilchos Schidus, 13 chapters. Hilchos Shalom Pekadim, 8 chapters. Hilchos Ma'av Lev, 27 chapters. Hilchos Talmidin, 16 chapters. Hilchos נחלות, 11 chapters.